Supreme Court dismissed the transfer petition in the matter of MS.SHRI, SENDHUR, AGRO and Oil Industries versus Kotak Mahindra Bank, while holding that no case is made out for transfer of the proceedings in question under 406 CRPC. Court said that for the purpose of transfer of any case or proceeding under Section 406 of CRPC, the case must fall within the ambit of expression expedient for the ends of justice. Mere inconvenience or hardship that the accused may have to face in travelling from Coimbatore to Chandigarh would not fall within the expression expedient for the ends of justice. Court laid down the broad factors which could be kept in mind while considering an application for transfer of trial as follows. When it appears that the state machinery or prosecution is acting hand in glove with the accused and there is likelihood of miscarriage of justice due to lackadaisical attitude of the prosecution, when there is material to show that the accused may influence the prosecution witnesses or cause physical harm to the complainant, comparative inconvenience and hardships likely to be caused to the accused, the complainant or the prosecution and the witnesses, besides the burden to be borne by the state exchequer for making payment of travelling and other expenses of the official and non official witnesses, a commonly surcharged atmosphere indicating some proof of inability in holding a fair and impartial trial because of the accusations made and the nature of crime committed by the accused, and existence of some material from which it can be inferred that some persons are so hostile that they are interfering or are likely to interfere either directly or indirectly with the course of justice, as it was also given in the case of Nahar Singh Yadav and another versus Union of India and others. The above mentioned factors are not exhaustive in nature and are illustrative of requirements of a fair trial. It is clear as a noonday that ensuring a fair trial is the predominant consideration for a court to rule on a motion for transfer of case. The Supreme Court, in case of Menka Sanjay Gandhi versus Rani Jethmalani, held that assurance of a fair trial is a first imperative of the dispensation of justice and the central criteria for the court to consider when a motion for transfer is made is not hypersensitivity or relative convenience of a party or easy availability of legal services like many grievances. Something more substantial, more compelling, more imperiling from the point of view of public justice and its attendant environment is necessitous if the court is to exercise its power of transfer. This is the cardinal principle, although the circumstances may be myriad and vary from case to case. Court said that we have to test the petitioner's ground on this touchstone, bearing in mind the rule that normally the complainant has the right to choose any court having jurisdiction and the accused cannot dictate when the case against him should be tried. As a general rule, it is the complainant who has the right to choose the forum that has jurisdiction over the subject matter, and the courts do not interfere with such a right unless circumstances that hamper the ends of justice are brought to the notice of the court by the other party. The transfer petition filed under Section 406 of CRPC in this case was at the instance of proprietary concern through its proprietor with the prayer to transfer criminal case titled as Kotak Mahindra Bank Limited versus MS.SHRI SENDHUR Agro Oil Industries pending in the Court of Judicial Magistrate First Class Chandigarh to the Court of Metropolitan Magistrate Coimbatore Tamil Nadu, essentially on the ground that no cause of action could be said to have arose for the bank to lodge the complaint for offence punishable under section 138 of Negotiable Instruments Act 1881 in Chandigarh.